So we will start with Mr. Baillie.
Thank you, Mr. Chair, and thank you for the invitation to present. Yesterday, you heard from Madam Justice Sheila Martin, who was my law school ethics prof. And one of the things that Sheila didn't talk about was a particularly difficult case that she had had a few years back. Dustin Paxton was charged with incredible abuse of his roommate, to the point that when the roommate was dropped off at the hospital in another province, he was so disfigured it took the hospital days to figure out his identity. Multiple experts, including myself, were involved in the case. Court clerks, police officers from 2 provinces, lawyers, and Madam Justice Martin herself. All of those individuals had access to mental health supports afterwards, and I know in varying degrees each was impacted by that particular case. Imagine then the scenario where an envelope shows up on your doorstep summoning you to jury duty. You're not an individual who typically spends much time in the justice system. You're not a member of the media. You're not a member of the legal profession. But you're compelled to show up and take responsibility for determining the fate of one of your fellow citizens. You're not appropriately compensated for that. In Ontario, there's no pay for the first 10 days that somebody serves on jury duty. In Alberta, we'll pay you $50 a day for showing up for jury duty. Every province, to my understanding, has a minimum wage standard, but we don't pay even the minimum wage to the jurors who are showing up to provide that responsibility. In fact, in some provinces, they'll even have to pay for their own parking. Childcare, other sorts of related expenses, those stresses start to add up. So the first thing that people do when they receive their jury summons is start thinking about, how can I get out of this? And so we end up with a situation where effectively people who are members of unions or people who are well paid in their other practices through passive income, for example, are the only folks who are able to serve on juries, hardly a jury of one's peers. And then imagine a trial such as either one of the 2 gruesome trials we had in Alberta earlier this year. Douglas Garland charged with the murder of the grandparents, Alvin and Kathy Lickness, and their grandson, Nathan O'Brien. Or Derek Soretsky charged with the murder of 3 individuals in southern Alberta. Each of those was a jury trial. Each of those lasted for weeks. Each of those involved graphic testimony. In the case of the Garland trial, there was evidence that Mr. Garland had hung the victims on a meat hook, which was subsequently tested for DNA that showed the presence of the victims. That meat hook was passed around, albeit in a plastic bag, from juror to juror, with the sound of the thud on the table as it moved through each of the participants. It's not surprising then that while people are thinking about the financial impact or the scheduling impact of serving on a jury, they don't spend as much time thinking about the mental health impact of serving on a jury. But we know, as my colleagues will tell you, some evidence points to the occurrence of post-traumatic stress, symptoms of anxiety, depression, anorexia, sleeplessness, and other forms of nervousness. And then at the end of the trial process, you're told in some provinces you may get access to 4 sessions of counseling over the next 2 months, or you may not get access to any sorts of counseling. But the very first instruction that a juror is given when they start their responsibility is the instruction from the judge that they are not to discuss this case with anyone other than the members of the jury when they are all present. So you heard 2 weeks ago the compelling stories of 4 jurors who sat on lengthy trials. And Mark, for example, is not able to talk to his friends or family members about what he's going through. When you and I have a bad day and we want to find some way to debrief and unwind, we talk to a spouse, we talk to a family member, we talk to a close friend, we may talk to a psychologist or other therapist. That's the way that we unwind, but jurors are specifically told that that tool's not available to them. In the Garland trial, we had Justice David Gates going out of his way to look after the mental health of the jurors. But now that caution, that support for the jurors, is actually one of the grounds that's being used in the appeal as suggesting that he was biased in his rulings by being so protective of the jurors' mental health. So we end up in this situation where we don't tell people what it is that they're getting into. We don't support them when they're in the process, and we give very limited support to them after the process. So what I'm proposing to you is a series of steps, and I'll put a formal document before you over the next little while, that deals with the information that should be provided to jurors before they get involved in jury duty, that reminds them of their own resiliency skills and the things that they typically do to look after themselves. It gives them more information about things like voir dires that are going to disrupt the trial process. So there may be days when they're not called to be there, and they have absolutely no information about what's going on. About some of the mechanics, about who's going to pay for parking and what sort of compensation they're going to receive. And then during the trial, a process that allows those people to have access to a counselor, a psychologist, or other therapist who's been appropriately designated by the province, who doesn't talk about the trial, but provides support to those jurors who may be in lengthy trial processes, about making sure that we have adequate compensation so that there isn't a financial stress that goes along with that. And perhaps in some of the longer trials, even thinking about having a mandatory break. You heard about a juror who served on a 10-month trial. There isn't a vacation break along the way. Nobody paid them to take a week off and not come in for jury duty. And yet everybody else who would typically be involved over a process of that length of time would be allowed to have a vacation. And then the things that we do afterwards. Juries, as you well know, are never allowed to discuss the deliberations. They're never allowed to talk to anybody about what happened in the jury room. But I can tell you that some of the jurors who've approached me over the last couple of years who sought out counseling because they found the provincial programs to be lacking have talked about how stressful that part of the process was. You've impartially listened to all the witnesses, you've heard the evidence, you've handled the exhibits. And when you get into the jury room, some of them have told me, there's been a unanimous decision about what the verdict is going to be, but then a lengthy discussion over hours and even over days about how each juror reached that particular decision. And the deliberation process, we know from some of the limited research on jurors, can be just as stressful as the rest of the process. So again, what I'm proposing to you, if you look at Section 10 of the Divorce Act, it allows for a judge to nominate an individual who would assess whether or not there's any possibility of reconciliation for this couple. And the information that's disclosed during that assessment process is never compellable in any other setting and cannot be disclosed even with the consent of the husband and wife. A similar condition that would allow jurors with a designated service provider to talk about everything that they've been involved with would then start to do the things that we need to do to look after the jurors' mental health. I look forward to answering your questions. I'm happy to talk more about this. It's something that I've advocated on for years, and I greatly appreciate the committee's interest in taking on this topic at this particular time. Thank you.
Thank you very much, Mr. Baillie.